Welcome back to the Constitutional Clarion. The recent attempted assassination of Donald Trump brought to mind the quite interesting story of the attempted assassination of Prince Alfred in Sydney in 1868 and its ramifications, particularly in relation to the offence of treason. Queen Victoria's second son, Prince Alfred, was undertaking the first royal tour of Australia and attending a charity picnic at the harbourside suburb of Clontarf in Sydney on the 12th of March 1868. As the Prince walked with the Chief Justice through the crowd towards the playing band, Henry O'Farrell pulled out a gun and shot the Prince in the back. According to the report in the Sydney Morning Herald, the Chief Justice, Sir William Manning, then sprang at the would-be assassin, who then jumped back and aimed his murderous weapon at Sir William. The gun misfired and Sir William ducked. He then lost his balance and he fell over. As he tried to get up, O'Farrell took aim at Sir William again, but another man then grabbed O'Farrell, pinning his arms and causing the shot to be fired towards the ground. It actually went through the foot of a bystander who then promptly fainted. Now, once the crowd realised what had happened, it was enraged. It called for O'Farrell to be hanged on the spot and they physically attacked him. He was saved by police who dragged his bruised and bloodied body onto a boat that was nearby and required the captain to sail them across the harbour so that they could take him to jail. Prince Alfred survived, being nursed back to health by two nurses that Florence Nightingale had recently sent to Australia. Queen Victoria herself wrote in her diary that the escape of, quote, poor dear Affy, unquote, from death was truly marvellous. O'Farrell originally claimed that he was part of a plot by Fenians, Irish republicans, to assassinate the Prince. But this was nonsense, and later he admitted that it was just fantasy. He had become obsessed with the wrongs that he thought had been done to Ireland, and in his rather poor mental state, he had responded by shooting the Prince. O'Farrell was quickly convicted and executed at Darlinghurst Jail on the 21st of April 1868, so a little more than a month after the assassination attempt. The shock and the shame about what had happened in New South Wales was profound. Public rallies and what were then called indignation meetings were held to give public expression to these feelings. I actually quite like the idea of an indignation meeting. I think we should have more of them. A good way to vent public feelings without resulting in violence. So these indignation meetings led to some positive outcomes. So, for example, it led to fundraising for the establishment of the Royal Prince Alfred Hospital in gratitude for the Prince's survival. That hospital still serves Sydney well today. The parliamentary response, however, was to enact a new law to deal with treason and disloyalty, which it did within 6 days of the shooting. Now, the British had previously realised that juries were reluctant to convict people of treason because it resulted in an automatic death penalty. Treason felony was therefore established in Britain as a separate offence which was punishable by imprisonment or, somewhat ironically, transportation to Australia. At least 4 of Queen Victoria's would-be assassins were actually transported to Australia. And one of them, interestingly, was also involved in the building of a hospital, although this time it was the Launceston General Hospital. So the Australian colonies already contained would-be royal assassins at the time of Prince Alfred's visit. The New South Wales Treason Felony Act of 1868 largely followed the British one. It in turn drew on the terminology from much older laws about treason going back to 1351, resulting in language which even in 1868 was really archaic. Section 1 of the New South Wales Act repealed earlier British laws to the extent that they applied in Australia regarding treason, except for those relating to, quote, compassing, imagining, inventing, devising or intending the death or destruction, wounding or imprisonment of the heirs and successors of King George III and the expression of such imaginings. Section 2 also made it an offence to seek to remove the Queen or her heirs and successors from the throne, or to overawe the Houses of Parliament, or encourage invasion. The unique provisions of this New South Wales Act, however, were sections 9 and 10. Section 9 said that if any person shall use any language disrespectful to Her Most Gracious Majesty, or shall factiously avow a determination to refuse to join in any loyal toast or demonstration in honour of Her Majesty, or shall express sympathy with or praise of a person who has committed treason felony, then he or she was guilty of a misdemeanour and could be apprehended by any person without a warrant. Conviction was punishable by imprisonment, with or without hard labour, for up to 2 years. Section 10 applied similarly to the publishing of words disrespectful to the Queen, but in this case the maximum penalty was 3 years imprisonment, with or without hard labour. A sunset clause was included which said that those 2 sections would expire after 2 years. The point of the provisions was to allow the arrest of Irish Australians who sympathised with O'Farrell or showed any form of public disrespect to the Queen by refusing to toast her health, for example, at a dinner. But the British thought these provisions went way too far. In those days, any law that was enacted in New South Wales had to be sent to London, and the British government could advise the Queen to disallow the law so that it would cease to be a law of New South Wales. Now, normally the British were more subtle about it. They would suggest that changes be made to the law and would hold off any disallowance until the law was actually fixed locally. So the British minister in charge of the colonies at that time, the Duke of Buckingham, wrote to the New South Wales governor saying that he thought that sections 9 and 10 were, quote, extreme in their scope and in the severity of the penalties, unquote. He said that he relied on the New South Wales government to prevent the abuse of these, quote, unusual, unquote, powers, and that he would wait before advising the Queen on disallowance until the New South Wales government advised him that it proposed to modify the sections. Now, this was a polite way of saying, change the law or I will advise the Queen to disallow it. Ordinarily, the New South Wales government would then just change the law and the public would be none the wiser about the British interference. But this time, curiously, the New South Wales government remained firm. It said that the New South Wales Parliament was better qualified to judge the need for such laws than persons residing in England. It claimed that it was universally admitted that prompt and vigorous action was necessary for the preservation of public order. It said that in a time of great excitement, the law was necessary to prevent the open and habitual expression of disloyal sentiments and the making of disloyal demonstrations. This time it was the British who surrendered. Perhaps it was just a bad look asking the Queen to disallow a law that was really intended for her protection and of her heirs. The Duke replied that the British government would not advise the Queen to disallow the law, but that this, quote, must not be considered thereby as indicating any approval, unquote, for sections 9 and 10. Now, sections 9 and 10 did expire after 2 years, but the rest of the Act continued. It was later repealed, but sections 1 and 2, the provisions about compassing and imagining the death of the monarch, deposing her, overawing Parliament or encouraging invasion, were reenacted as sections 11 and 12 of the Crimes Act 1900 New South Wales, where they actually still remain in force today, despite their peculiar and somewhat misleading language. So, should Republicans in Australia be worried, or indeed anyone who has imagined the death of the monarch? If so, all those people who assiduously planned the funeral of the late Queen Elizabeth II would have been in strife. Back in 2003, the Guardian newspaper took proceedings in the United Kingdom to seek a ruling on whether or not it was breaching the equivalent UK treason felony provisions if it published a series of articles proposing a republic. The members of the House of Lords, that is the court, were none too impressed by what they perceived as a waste of their time. Lord Scott stated that it was, quote, plain as a pikestaff to the claimants and to everyone else that no one who advocates the peaceful abolition of the monarchy and its replacement by a republican form of government is at any risk of prosecution, unquote. He doubted that there was any school debating society that had not regularly addressed the issue, and he observed that they had not been receiving visits from the special branch. The provisions are not intended to catch proposals for peaceful change to governmental systems. Instead, they were directed at change by the imposition of unlawful force. A fellow judge in that case observed that freedom of speech is a, quote, core value of our legal system, and that it's difficult to think of any rational argument justifying the criminalisation of the conduct of citizens who wish to argue for a different form of government, unquote. In Australia, the application of the constitutional implication of the freedom of political communication would also affect the interpretation of the treason felony provisions in New South Wales. Criticism of the present system of government and proposals for peaceful reform could not be criminalised by the state, as this would breach the implication in the Commonwealth Constitution. Equally, imagining the monarch's death, in the common meaning of the term today, does not amount to treason unless it involves planning to cause the monarch's death. Apart from these rather odd state provisions on treason, which are hangovers from colonial times, the primary treason provisions in Australia are contained in the Commonwealth's Criminal Code and use more modern and precise terminology. Section 80.1 says that a person commits treason if they cause the death of the sovereign's consort and heir apparent, the Governor-General or the Prime Minister. It also includes levying war against the Commonwealth or instigating an armed invasion of the Commonwealth. There's a separate offence for aiding a declared enemy in armed conflict against the Commonwealth. The reason for mentioning this is that you'll often find people in the pseudo-law world who will throw around accusations of treason, but they actually have no relationship with the actual terms of the real offence of treason. As for overthrowing the Constitution, that comes under a different offence of treachery in section 80.1 capital A capital C. It provides that a person commits an offence if the person engages in the use of force or violence with the intention of overthrowing the Constitution, the government of the Commonwealth, a state or a territory, or the lawful authority of the Commonwealth Government. To state the obvious, proposing the reform of the Constitution through lawful means, such as a referendum, which involves no force or violence, comes nowhere within cooey of treason or treachery, despite some of the claims that you will have seen on the internet. Indeed, why would the framers of the Constitution have included a referendum as a means of amending the Constitution if all proposed changes to the Constitution amounted to treason? Proposals to reform the system of government would also be protected by the implied freedom of political communication. Finally, there is one mention of treason in the Commonwealth Constitution. It provides in section 44.2 that any person who is attainted of treason shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. This is interesting because it's the only offence that results in that absolute ongoing disqualification. A person convicted of any other offence that is punishable by imprisonment for 1 year or longer is only disqualified while they are under sentence or subject to be sentenced. Once their sentence is completed, they're no longer disqualified. Hence, a conviction for treason was regarded as so serious as to permanently disqualify a person from sitting in Parliament as opposed to any other kind of offence. But could a person convicted of treason ever plausibly be elected to Parliament? Well, the answer is yes. It actually did happen to an Australian man born in Victoria of the name of Arthur Lynch. He fought in the Boer War against the British. And later, while living in Paris because there was a warrant out for his arrest in Britain, he was elected to the seat of Galway in the British Parliament in 1901, despite never having set foot in his constituency. He was arrested upon his arrival in the United Kingdom to take up his seat in Parliament. He was tried and the jury took all of 26 minutes to find him guilty of high treason. He was sentenced to death. This caused his seat to be vacated, as indeed it would have done in Australia. Fortunately for Lynch, he had good friends in high places. They included the US President, Teddy Roosevelt, who allegedly wrote to the King, King Edward VII, to secure the commutation of Lynch's sentence to life imprisonment. After further interventions by famous friends, he was actually released from prison after serving only 1 year. But Lynch wanted his seat back. He wanted to represent the people in Parliament, and he couldn't do so with that conviction of treason. So he lobbied for a pardon, which he eventually received. In 1909, he was elected to the British House of Commons, in which he served until 1918. So even though conviction for treason does result in a permanent disqualification from Parliament in the United Kingdom and in Australia, this can be undone if a person is pardoned. Thank you for watching the Constitutional Clarion. I hope you found this quite interesting. I did. And I look forward, as always, to seeing you next time. Goodbye.